Imagine having all of your title reports at your fingertips anytime you needed them. It's possible with Judicial Title's View a Title feature online. Simply go to judicialtitle.com/view a title or go to our website and click Resources and Title Report Online. Once you're there, you can sign up for an account, put in your information, and click Submit. Once you've done that, simply sign in. I'm going to use a mock account for our purposes. Once you've logged in, you can see all the title reports you've ever been on. No matter if you're the buyer's attorney, the seller's attorney, the lender's attorney, they'll all be there. I'm just going to click a sample, and you can see all the information: general information, closing information, the parties on the deal, municipals, the dates they were ordered and received, and recording information, including LIBOR and page. Also from here, click Download Title Report, and you can view the title report. We hope you'll find this tool useful and time-saving. If you have any questions, just email info@judicialtitle.com.
Thank you, Diana, and thank you for all the work you do and all the efforts you put into these CEs and CLEs. This was a special one, and we're going to try to do more videos as we go along, because when you get old like I am, I'm over 60 now, you'll forget all this stuff. So anytime you want to know what to do, we're going to have a video, instruction video for you. So you can just go to Diana. She'll send you the instruction video. You always have it. We think this was kind of important. A lot of attorneys are looking for old policies or old title reports or old surveys. You could find it. A lot of attorneys work at night now or in the weekends. Thank God for COVID, right? And they are able to view all this after hours. So we think it's kind of important, and thank you for it. The CLE today was with Charles Brundage, and Charles Brundage is celebrating his 20th year in title. Congratulations, Charlie. He started May 2001, so 20 years in title. I think it's like once you're in title, you always stay in title, pretty much that we say all the time. The CLE is obviously going to be a webinar, and we're going to continue doing these webinars all through the summer and all through the rest of the year. However, we plan on having live CLEs in the future. We will contact you with dates and times and places. And now with a lot of things opening up, I think it'll be a lot easier. And I enjoy seeing people. I kind of miss talking to people. I kind of miss the camaraderie we all have. And I look forward to getting back to normal and having live CLEs. But these CLEs also serve a great purpose, and we're going to still continue to have these CLEs. The big upcoming event for all the attorneys is the new power of attorney. It is effective June 13th, 2021, and it has some changes on it. And for the most part, for title, it's not going to be that much different. We will have the new power of attorney online by June 1st. We could probably get to you earlier if you want to email to you. We don't want to confuse people who will be closing before June 13th. So around June 1st, we'll put the new power of attorney on, and we'll go from there. So I'm going to kick this off to Charlie again. Congratulations, Charlie. 20 years in title insurance. Who would have thought it, right?
Who would have thought it, yeah.
And I really like that giant poster back there. So I think that adds to the CLE, Charlie. So good luck and enjoy. Thank you.
Thank you. Thank you, Richard. I'm going to share my screen now with the PowerPoint presentation so everybody can see it. Okay. Hopefully everybody can see that now.
Just do slideshow from beginning.
Oh,
so
yeah.
Full screen. Thank you.
Thank you. Slideshow from beginning. There we go. Okay, perfect.
Perfect.
All right, thank you. All right, welcome everybody. It's nice to have these online. I agree with Richard. I would like to see everybody in person again at some point soon. But the webinars are very effective, and they're very convenient for everyone as well. So this one is about the top 10 reasons that closings get adjourned that we have seen over the years, and nobody wants to have a closing adjourned. There's a domino effect when there's an adjournment. It affects the buyers, it affects the sellers, it affects everybody. Nobody gets paid if there's an adjournment. That's just not good. And when a title company has to adjourn a closing, obviously nobody is happy. So we want to make people happy in this business. It's supposed to be a good time, and not a good time in people's lives. There are a lot of, especially for residential deals, which we're going to, talk about mostly. On residential deals, it's usually the biggest purchase of someone, a couple's life or a person's life. So we want to get them to close. Saying that, we're going to look at the law, obviously, on a lot of these reasons and how to avoid them, adjournments. But title companies are businesses. We're not courts. So, just because something could be legal doesn't mean we have to take the risk. A lot of what we do in title is not driven by legal only. It's driven by business decisions and risk assessment. We have underwriting criteria, obviously, that we have to follow. It's different for a sale versus a mortgage. And then we have recommended title practices, which are recommended but not mandatory. One of the ones that comes up most often that changed over the years a little bit was the small ancient mortgage rule. That one where you can get a mortgage omitted from a title report if it's small enough and ancient enough, 30 years old or more and $50,000 or less. So that's something that changed. It used to be 25,000. Our underwriters increased it to 50,000. So another thing underwriters did shift in underwriting policies. Franchise taxes are no longer requested. We don't hold escrows for them. We don't treat them as a title problem because there's never been a claim for franchise taxes. When you have a corporation that's been dissolved for failure to pay franchise taxes, they can sell as an act of winding up the corporation. And then there's been changes with the LLC laws over the years. As far as what you're looking for, what the contract calls for is insurable title, which is less than marketable title, and who decides what insurable title is, but the title insurance agent and the company. So we do that by examining title, reading title, and figuring out who's in title and who can convey and what liens are on the premises. We get clearance from other title companies down the road for that were on the deal prior, or 2 or 3 deals prior. How did you take care of this mortgage? Were you able to omit it? That kind of thing. So we do that all day, and we deal with C of Os and violations of housing and building issues, even though they're not title issues. We don't insure, we don't accept or omit those, but they can stop a closing pretty easily. A bank is not going to close. Usually a lender will not close if there's violations on the property, or if there's not a valid C of O. Okay. One of the big reasons you want title insurance, sometimes, clients will ask, why do I have to get this? Well, if there is a claim in the future, which usually there isn't, but God forbid there is, you can go to the title company and submit that claim. You're going to go to a deep pocket, which is a title company, title corporation, and deal with them rather than having to go chase the seller who gave you a warranty and a warranty deed. Good luck doing that. Obviously, there's owner's insurance and mortgage insurance, and simultaneous rate is offered. We have reissue rates and bulk rates. So if you ever have questions on, what the premium is, just, give us an email or give us a call, and we'll help you out with that. Now, before we get started with reason number 10, just practical and sometimes not legal things that could mess up your closing and cause it to adjourn. No homeowners insurance, that would be a problem. Missing a payoff letter, which is, obviously not a legal issue, but it is a title issue. It becomes a title issue because we need to pay off that lien. It's hard to get a payoff letter in 24 hours. Some banks are better than others. There's fewer local banks rather, very few local banks anymore. And then, what's on that payoff letter? There could be a prepayment penalty that the borrower wasn't aware of or forgot, the seller rather. And there could be legal fees, which could be mean that they're in foreclosure, and that brings up a whole host of other issues. Okay, so as I said, we're gonna concentrate on adjournments based on statutory and case law, but we're also going to look at risk assessment and business decisions. A lot of things can be omitted with a monetary escrow, but you can't throw money at everything. Reason number 10, starting there, would be when you have an executor or an administrator trying to give a power of attorney to a third party. This can't be done. Fiduciaries cannot delegate their authority. The duty of a fiduciary is personal. The decedent placed his or her trust in the appointed executor. So the fact that they want to give a power of attorney is statutorily not allowed. Now, an attorney, in fact, can be used to execute ministerial duties, to delegate ministerial duties to a third party. So you could give a power of attorney, for example, to fill out and sign the TP 584, but you couldn't do it to sign the deed. And an executor who hires an assistant, this is just a little aside, must be prepared to pay that assistant out of commissions, but not out of the estate funds. The fiduciary could resign. If they don't want to act or can't act, they could resign under the SCPA. And then you come into the area where you have a fiduciary coming to the closing, but they can't act at all because the prior deed conveyed title directly into a trust or estate. Unless that conveyance was made to John Smith as trustee of the Brown Personal Residence Trust, that deed is void, and then the title would still remain in the grantor. So you want to be very careful when you're dealing with trusts and title issues. Make sure you read Schedule B and see what we're saying about the trust. If the deed was into the trust directly, then they're not going to be able to deed out. They're going to need a correction deed. You need to name those trustees. Okay. Corporations can convey title by attorney. In fact, they don't use a power of attorney. They would use a distinct corporate resolution. And an LLC can do that as well by giving an LLC resolution to appoint an attorney to act for them, or one of the managing members to act and sign all the documents at closing. Now, important facts about the power of attorney: must be in recordable form. If you're signing a deed or a mortgage with it, we're going to record it. It has to be recorded with the county. It's got to be the durable short form, which is changing, as Richard mentioned, and we're going to be getting a new power of attorney soon. June 13th is when they're going to be, the new power of attorney is going to become effective. It terminates upon the death of a donor, and if it's recorded, it can't be revoked against the party relying on it unless the revocation is also recorded. You have to have people on notice. At a closing, when a power of attorney is used, we're going to be looking for a full force and effect affidavit, and we're going to look for the deed to recite full consideration because they are fiduciaries. So now, would this closing be saved? Unless the fiduciary is in close proximity to the closing, this closing is most likely going to be adjourned. Okay. Seller number 9, or reason number 9 rather. Seller does not come to the closing with certified funds for transfer taxes for his title bill. Title companies do not take personal checks for transfer taxes, or for sellers, any seller's fees, transfer taxes, real estate taxes, anything that's on the seller's bill. They're going to want a bank check, certified funds, or an attorney escrow check. Now, why? This is just a business decision. You know, you could try to get prior approval, which, you know, would be if you had a very good relationship with the title company. But I would venture to guess that most, if not all, title companies are not going to take a personal check for seller's fees because, you know, unlike the buyer who is getting a policy from you, the seller, we don't know where they're going after this. You know, they're gonna disappear, and we don't want to be chasing sellers for multiple thousands of dollars in a lot of cases. So the contract is going to tell you who pays the transfer tax and how. Certified or official bank checks is usually what they're going to want. It's going to the distinction between transfer tax and recording tax. Mortgage recording tax is paid by the buyer, and the quarter point is paid by the bank. Transfer tax, you could have a continuing lien deduction, depending on if it's in New York City or just in New York State. There's different criteria if that can be used. And just be aware that it exists, that there is a continuing lien deduction in both city and state on the transfer tax form. And if you have questions on it, just give us a call or email us and we'll go through it with you. The seller pays New York City and New York State transfer taxes. And then you have the mansion tax, which is paid by the buyer. Now it's 1%. Paid by the buyer on the purchase of residential property, which is a 1, 2, or 3 family house, an individual co-op, condo unit, or co-op unit for consideration of $1 million or more. Now, if the purchaser is exempt on that, for let's say they were a not-for-profit corporation and they're exempt, then the seller's got to pay under New York tax law 1402A. And you want to avoid surprises at closings. We all do. You want it to go smoothly. And one of the ways you can avoid surprises is to, if you don't practice in an area, give us a call. If you don't regularly practice in an area, like let's say, Suffolk County, and you're in Westchester and you don't normally represent buyers or sellers in Suffolk County, but you have a deal there, give us a call or email us and ask us if there's anything I need to look out for. Are there any special transfer taxes? Is there a special mortgage recording tax? What is it? In the case of Suffolk County, if you don't practice there normally, there is you want to familiarize yourself with the fact that there's the Peconic Bay transfer tax. It's Southampton, East Hampton, Shelter Island, those kind of places out in the Hamptons. It's 2%. It's payable by the buyer. I always remember it, who pays it by thinking it's the, saying it's the entry fee to the Hamptons. It's 2% minus some small allowances. So if you had a $3 million house in East Hampton, which is not hard to do, not hard to have, that would be a tax of $55,000. And you don't want to be surprised by that, obviously, nor does your client. So just always give us a call and we'll be as helpful as we can about the local areas, finding out if there's any traps there. Now, all of these transfer taxes are negotiable. They can shift the burden in the contract. The seller can have the buyer pay transfer tax in the contract. So just watch out for that. Usually that is the case when it's a New York City condo or just a condo coming out of a sponsor. And they almost always shift the burden onto the buyer to pay the transfer tax. And then another thing to look out for with condos is if you have a purchaser who's buying 2 apartments in New York City, that's going to be taxed at the highest commercial rate because it's not considered a single condo unit. And then if they're paying the transfer tax, they're going to bear the burden of that. And when the buyer pays transfer tax for the seller, since it's not their responsibility, it's considered consideration. The payment of that tax is considered consideration under the contract. So they're going to bulk up that transfer tax, and it's going to be higher. We're going to add in the transfer tax and make it part of the consideration. One thing a condo contract cannot do is tell who the title company is going to, you have to use ABC Title Company. That can't be done. It's a violation of insurance law. They can suggest, say, we work with Stewart Title, we work with First American, order title with them because they've already, cleared up a lot of the issues. But they cannot demand that you use them, and they cannot force a penalty clause either. Now, so could this be this closing saved under this scenario where they don't have a check for transfer tax, a certified check or bank check? They can pay with credit card, and then we would cut our own check and pay the transfer tax. The problem with that, with an attorney guarantee, let's say the attorney wanted to guarantee the check because he knows the client well. If the check bounces, then both the attorney and the title company are in a strange spot, awkward position. You don't want to have that. So if you're selling, make sure you bring a certified or bank check. As I said, there's different tricky transfer tax transactions. I'm not going to go through each of these, but they're in the material. And call us if you're not sure. What the transfer tax is going to be. If it doesn't look right on your bill, give us a call, email us, let us. We'll go through it. There's different scenarios with foreclosures, deeds in lieu of foreclosure, bankruptcy transfers, purchaser paying the transfer tax, as I mentioned before. That's going to be bulked up. So if you're not sure of the calculation, just give us a call and we can run through it with you. We've got to make sure that we file the papers on time. The New York City gives you, penalties for late filing. The penalty is 5% of the original tax due for each month or a fraction of a month that it's deemed late, and it could be as high as 25%. So we want to make sure that we get everything in on time. Okay. Reason number 8. That closings get adjourned. The buyer and his attorney are not aware that the bank will deduct the closing costs from the mortgage proceeds. So instead of having the full mortgage proceeds to give the seller, the buyer puts a personal check on the table for $10,000 and change. That's not going to work. As you know, the contract of sale calls for certified funds for the balance of the purchase price. Unfortunately, this is the net proceeds trap. The solution to this, of course, is for the buyer's attorney to get the net proceeds ahead of time. However, that's not always, you're dealing with a bank attorney that sometimes is going to be emailing mortgage docs and breakdowns. The bank is just getting it to the bank attorney late. The bank attorney is getting it to you late. It's kind of just, domino effect, or rolls downhill. What you can, if you don't have that, you can compute your own net proceeds. You can use the attached worksheet that's in the materials and your good faith estimate from your title company. You can call us or email us and ask us for a final title bill with taxes on it and everything that's going to be picked up from the buyer at closing, and then you'll know exactly, you should know exactly how much you have available. So the amount hasn't changed, that's due from the buyer, but it's the form in which it's brought to closing. So he's not getting the full proceeds from the mortgage. Got to bring money to the table, and it's got to be certified funds. Okay. This leads us to a short discussion of the seller's concession. That's when the purchase price is inflated to include a credit for repairs, resulting in 100% financing or more. This is okay, obviously, if it's disclosed and if the bank is aware of it. I don't know that we see this too much anymore. I haven't had to deal with it lately. I haven't come across a title where this was an issue. Probably maybe once in the last 6 months I've heard of it. So basically, hopefully it's not going to be an issue to, adjourn a closing at this state of affairs, because It's not used as much anymore with the collapse of the subprime mortgage market. Banks aren't doing 100% financing. At least I haven't seen it recently. But if it is going to be done, if you're going to do a seller's concession, then disclosure of the grossed up sales price and the seller's concession on the contract of sale should be deemed sufficient disclosure to make it, ethical conduct. Post-conduct or post-contract gross ups are ethical too, as long as it's everything is mentioned on the closing statement, HUD 1 if they're using that, or CD, and 5217. Now, we had some discussion about it with the real property section. Most part reflects the recommendations. The dissent calls for even less disclosure on this. You can read through this material. We don't have to go through it line by line, but just to suffice to say that a seller's concession can be ethical and can be legit as long as it is disclosed timely and disclosed on the either in the contract or post-contract through an amendment to the contract. The concessions are driven by the secondary mortgage market. Almost never a lawyer's suggestion, was always usually coming from a real estate or a mortgage broker. And in our opinion 817 that's included in your materials incorrectly suggests that fully disclosed seller's concessions are inherently fraudulent or misleading to the secondary mortgage market and the general public. And that opinion really doesn't give clear guidance to the practitioner. We recommend that you, as I said, if it's fully disclosed, the concession is not inherently fraudulent. It can be legitimate. Now, will this closing be adjourned? This one that we were talking about with the net proceeds problem. The best thing can happen is the parties and attorney just wait while the buyer goes and gets certified funds. Hopefully they can do that. If not, then the closing will be adjourned. And if you have an undisclosed seller's concession, the closing will certainly, most likely be adjourned as well. Okay. All right, reason number 7 on our list of top 10 reasons that closings get adjourned. The executor of an unprobated will arrives at a closing to execute the deed. The will has not been probated. We need letters testamentary, which means that the probate court, surrogates court, has signed off on the transaction. They have signed off on the will and, appointed an executor that can sell the property. Any property, with respect to any property or any estate therein owned by an estate or trust, except where such property or any estate therein is specifically devised. So that's what an executor has power of. They have the power of sale over any property that the decedent owned at the time of death that hasn't been specifically devised. And they can sell it at public or private sale. Fiduciary is a personal representative, obviously, a person who has received letters to administer the estate of a decedent. A preliminary executor has the authority to convey real property. So a lot of people don't know that. That is a good thing to know. You don't have to have permanent letters. If you have preliminary letters for an executor, as long as they don't have any limitations on them, then they can be used. Now, in the title report, when we have estates in title, and we see an estate in title, we're going to raise the exception that the letters have to be updated if they're not within 6 months or more. That's statutory. It's not, we didn't just make that up. That is a statutory reason under the SCPA. It says basically if they're 6 months old or if they're more than 6 months old, they're stale. So we are going to look for updated letters when they're not within 6 months. Don't wait till the last minute. Obviously, with COVID and everything, I wouldn't wait till you get the closing date to make sure you have letters that are issued within 6 months. I would make sure from contract stage, what what's the status of the estate? What is the status of the estate? Of the executor's letters testamentary, or if it's an administrator, then letters of administration. Are they dated within 6 months? Are they going to be acceptable? Okay. And then can this closing be saved? Well, probably not. You would need all the heirs at law of the decedent. They'd have to come to the closing. They'd have to convey title pursuant to an heirship affidavit. And one of the changes that we've seen recently with our underwriters is they would have to, the decedent would have to have died 2 years ago or more. If they died within 2 years, then we could not convey using an affidavit of heirship. We'll talk about that in depth a little bit later as well. Now we're going to talk about religious corporation. Reason number 6, let's say a religious corporation arrives at closing without a Supreme Court order authorizing the sale. Not going to work. Without such order, the conveyance is void. Religious corporations are more heavily regulated than not-for-profit corporations. So the first step in your analysis is to see what's required is an examination of the organizational documents. The not-for-profit corporation law applies to religious corporations. So in addition to court approval, and the consent of 2/3 of the directors must also be obtained. The law states a religious corporation shall not sell, mortgage, or lease for a term exceeding 5 years any of its real property without applying for and obtaining leave of the court. That's section 12 of the religious corporation law. Obviously, the intent is to protect the congregation from dissipation of church assets, stealing the assets, that kind of thing. And the requirement extends to the sale, lease, or mortgage of all property owned by a religious corporation, not merely property used as a place of worship. So it doesn't have to be the church itself, the church property, for it to require this court order. If it's any property that the church owns. Now, the church can enter into the contract, a religious corporation can enter into a contract prior to court approval. But the contract has got to be conditioned upon court order. If it's not, then the purchaser's rights are going to remain intact. So if you're representing a seller that's a religious corporation, make sure you condition it, make sure you make it contingent upon them getting the court order. And that court order is going to have to conform to all contractual terms. And then there is a carve-out, a property acquired by a religious corp at a foreclosure sale of a mortgage that it holds, or a deed in lieu of foreclosure does not require a court order for the subsequent sale. That's also Religious Corporation Law 12, subsection 10. Also, certain churches are exempt. For example, the Archdiocese of New York does not need to get a court order to sell their property, but the smaller churches do. Okay. A mortgage also by the religious corp is going to require a court order. Without it, the mortgage is unenforceable and cannot be foreclosed. The carve out here is a purchase money mortgage does not require a court order. So if the church is doing a refi, the religious corp is doing a refinance, then we're going to need a court order. If they're buying, we do not need a court order for the purchase money mortgage. Bad drafting, lack of a comma has caused some people to erroneously conclude that a mortgage for a term of less than 5 years does not require an order. This is not true. It's all mortgages except true purchase money mortgages require a court order for a religious corp. Must be strict compliance with the order approving the transaction. So if the contract or mortgage terms are amended, the court order must also be amended. A title company is not going to insure the conveyance by a religious corporation without a court order. No escrow or undertaking to obtain a court order confirming the conveyance after the closing will be sufficient. So you've got to make sure if you're selling, you have this order. We can't hold the proceeds in escrow because we don't know if the order is ever going to come. It's just too much risk. And we can't obviously take an undertaking. We need it at the closing. We can't get it following the closing. We're not-for-profit corporations, as I mentioned before. They're very, closely related to churches, to religious corporations. So we're going to talk about that real quickly about when they need a court order. There's 4 types of not-for-profit corporations, and only a type B or C require court orders for conveyances of all or substantially all of their property. However, that is the case when we see a not-for-profit corporation selling, we're going to ask for a court order unless you convince us otherwise that we don't need it. You got to tell us, show us what type of not-for-profit corporation is it? Is it an A type? Is it a D type? If it's a B or C and it's substantially all of their real property that's being conveyed, or their property, we're going to look for that court order. Now, obviously, the difference is a religious corp. You need whenever they're going to sell, you need a court order, but only a sale of all or substantially all of the assets of a not-for-profit would require it under the not-for-profit corporation law. And what is the court going to look at? They're going to make sure that the price is fair and it's in the best interest of members for a not-for-profit corporation. And just to know, a mortgage by a not-for-profit corporation does not require a court order. As I said before, this closing if you don't have that, you have a religious corp and you don't have a court order, no, we're not going to be able to save this closing. It's definitely going to adjourn. You're going to have to get leave of court to sell the property. Excuse me. Okay. Reason number 5. Seller arrives at the closing with a payoff letter that shows legal fees due. Now, this raises a couple of different things. If there's legal fees due, they're in foreclosure. We want to know, are we getting the most up-to-date payoff letter? Do we have all the legal fees that are owed? We also need an undertaking from the foreclosing lender, or the firm that represents the foreclosing lender, that they'll cancel list pendants, terminate the action, the foreclosure action. We would obviously not want to insure a transaction and have the foreclosure go through, because then we'd have a full failure of title. We don't want that, obviously. Also, when we see that there's legal fees due, this brings the property into the Home Equity Theft Protection Act. Now, that was established effective back in February of 2007 under Section 295A of the banking law and Section 265A of the real property law. And it was a response to, at the time, the alarming rise in home equity theft. There's a list of everything that the Act requires. It's in their materials. This was pretty much a scam thing that was happening back then, where people were going into contract with someone, with an owner, saying, that's in foreclosure, saying, we're going to bail you out, we're going to, take the property from you, buy the property from you, and sell it back to you later. They would just, take all the equity out of the property, and that's equity theft at its core right there. And what that act has is there's a 5-day cancellation period. So if the buyer is buying the property and letting and there's contract language, reconveyance language on the contract, then the act would apply, and you have a 5-day cancellation period. You could have a buyback agreement in return for bringing the mortgage current. And this was just a big mess for title companies. How do we get you out of the act? We would take an affidavit that from the seller and from the purchaser also at closing. Whenever the file's in foreclosure, we're going to look for that. We're going to look for affidavits from both parties, and we need to know that the purchaser is going to use the property as their primary residence. They're a bona fide purchaser or a cumbersome for value. So this takes it out of the fact that they're buying it and leasing it to the, having the person stay in, the seller stay in the house, even though they're not entitled anymore, and become a lessee, and then a buyback agreement. We get the affidavit that the purchaser is going to use the house as a primary residence, and that they're a bona fide purchaser for value. If it's a deed from a referee, that takes it out of the act. If it's pursuant to court order, that could take it out of the act as well. That would. Or if it's a deed from a spouse, parent, grandchild, child, etc., or a not-for-profit housing organization. Now, if it doesn't come out of the act, you can't close, because you would have it basically prevents the act prevents title insurance, because it allows the equity seller, the person who's staying in the property, to cancel this any transfer that is in material violation of the act for 2 years after the recording of the deed. So obviously, no title company was ever going to insure these. So we're not seeing these, these scams as much anymore. So luckily, we're not seeing those anymore, and hopefully we won't see them at all. Reason number 4, running a little bit behind, so I might have to speed through a couple of these. The intestate deceased owner's daughter, who lives in the house, shows up at the closing to execute the deed. No, we need an administrator. If the decedent died intestate, that means without a will, obviously, we would need an administrator appointed. We need letters of administration. Or we could take a deed from all the heirs of law if the 2-year period has passed. So in this scenario, you've got a daughter who comes to the closing, wants to sell. She says she has a brother, but states he has no interest in the house. What she means is that he's not interested in the house. But legally, obviously, any heir of the decedent that dies intestate has a interest in the house. So we'd have an administration here, no will. The administrator is going to be appointed to handle the decedent's affairs, and they get letters of administration. And again, those letters have to be dated within 6 months of the closing. Also, with an administrator, you need a bond filed in the amount of the sales price. It's got to be posted, or there's got to be some evidence in the estate proceeding, in the administration proceeding, that there was no bond required. In the case where there are no heirs, then the people of the state of New York become the owners, and only the public administrator can convey. That's pursuant to abandoned property law. Now, if the 2-year period, this is something that changed, because prior to maybe 2-3 years ago, we would, title companies would, take affidavits of heirship for almost anything, almost any kind of transaction. That's been tightened up by our underwriters because they've had claims. There's been claims on heirship affidavits. So we would have to be a simple heirship, a simple estate rather, where you'd have a spouse and children. You wouldn't be going, past that to, siblings and that kind of thing. We need proof of death. We need a death certificate. We don't need it. We can't take an affidavit for that. We need a death certificate. And the decedent, as I said, would have to have died 2 years ago or more than 2 years ago. We need proof that there's no will, or that the will only had monetary bequests, nothing coming out of the real property. We need proof that none of the heirs are minors or under any disability, because if they are, then obviously we would have to get a guardian appointed. So if it is a simple estate and it's been 2 years, then yes, by all means, we could do an affidavit of heirship, because an administration proceeding really is a formal affidavit of heirship. No, but if it was up to our underwriters, they would want an administrator appointed in any deal where there's no will. Obviously, it's more risky to accept a deed from heirs as opposed to a deed from an administrator. But the 2-year period has been established because statutorily under the EPTL, a good faith purchaser from the statutory heirs will not be affected by a testamentary disposition of the real property unless the will was admitted to probate within 2 years of the testator's death. So that's where that 2-year period comes from. Excuse me. And also that 2-year period holds true for an executor appointed in another state. Excuse me. We're not going to require ancillary letters to sell real property if the affidavit of heirship is acceptable substitute and 2 years have passed since the date of the death of the owner. Okay. Number 3, the seller.
Go to reason 3. Can we have the course code?
Oh yes, absolutely. I'm sorry. The course code is giants. So hopefully we'll have a good season this year. Already looking forward to that. A seller, reason number 3, a seller shows up with a judgment against him, docketed against him, that was discharged in bankruptcy. And she thinks she can sell the real property free of that judgment. No, she can't, because unless she's done an extra step, which we're going to talk about. There are 2 parts to a judgment. There's a debt and there's a lien. The bankruptcy only discharges the debt, which is the personal obligation. You've got two types of bankruptcies that we see. Mostly are the Chapter 7, which is liquidation, and then Chapters 11, 12, and 13, which are reorganization. We deal mostly with liquidation cases. The bankruptcy rules technically require the filing of the bankruptcy petition in the county clerk's office. That's almost never done. And we would only really be on the hook for a claim, the title company, that is, if the petition was filed in the clerk's office. But as you all know, when you see your title reports, we run independent searches in the eastern and southern districts, depending on where the property is. And by doing this, we extend our liability and must deal with the findings. So what we're talking about here in reason 3 is a judgment against a discharged debtor. And it is one of the hardest conversations to have with, with an attorney or their client. Because they're going to ask, if the judgment is discharged, how can it still be a lien? The problem is, it's settled law that the bankruptcy only relieves a debtor from his personal obligation to repay the discharged debts. So the debt and the lien, you have 2 parts of a judgment. The debt has been reduced to a judgment. The discharge does not remove the judgment as a lien, unless under the bankruptcy law, they have to file for an unqualified discharge or a motion to avoid the lien. And the Carmen case talks about that, says that, basically that an unqualified discharge gives notice to third parties that property may still be burdened by liens. You've got it's just a simple motion that's made in bankruptcy court. I'm not sure why it's not done on every case. And these sections are attached, so you can review them afterwards. If they did not do it in the bankruptcy case and they don't want to reopen the bankruptcy case to do it, to make a motion to avoid the lien, then they can do it post-closing or post-bankruptcy. Post-bankruptcy. They can go to New York State Court, and under Section 150 of the debtor-creditor law, this is a post-discharge proceeding in the state Supreme Court to remove the lien against debtor's real property. It's obviously a corrective remedy for a failure to make that motion to avoid the lien in the bankruptcy proceeding. How would we deal with this if we were at the closing? We're going to want that order avoiding the lien in the original bankruptcy proceeding, or we're going to want an order pursuant to Section 150 debtor-creditor law. We could hold an escrow. We could, because it is, when you have a discharge, it is pretty much, standard operating procedure that the New York court would guarantee, or would grant rather, the discharge, or the unqualified discharge under Section 150. So we could hold, say, $10,000, maybe around that amount, and close. Okay. Obviously, if it's post-petition, post-bankruptcy proceeding, and it's real property that they did not own at the time, it's new property they're buying, they're not, there's a fresh start philosophy of the bankruptcy law that says it's, once that discharge is there, it's not going to be a lien against new real property acquired by the, after discharge. And then we've got lots of stuff, lots of material dealing with the bankruptcy procedures in our material. Reason number 2, a probated will results in letters testamentary issued to 2 executors, but only one attends the closing to execute the deed. And you don't have the deed pre-signed. That's not going to work. When you've got 2 executors appointed, they both must execute the deed. Statute is clear. CPTL section 10-10.7. When there's 3 or more, you can do a majority, but when there's 2, you need both of them. And as we know from reason number 10, the fiduciary cannot delegate this authority to sign the deed. It's not a ministerial act, so he or she's going to need to sign that deed. We need letters, valid letters of testamentary or letters of administration. There's a good little known fact that by statute, a deed executed by 1 or more, but not all of the executors have been appointed, will become valid 10 years after the deed has been recorded. So you could rely on it after 10 years. But obviously, in our situation, we're going to want all the executors to sign that deed. If there's 2 executors, we need them both. Estate taxes, we know about New York estate tax and federal estate tax. We're going to want either a release of the lien when we deal with estate tax, or we're going to take an affidavit that the estate is under the exempt amount. And then obviously a surviving joint tenant or tenant by the entirety can convey to a bona fide purchaser a value free of the lien of estate taxes. Okay, so in this case, would we be able to save that closing? We wouldn't unless the executor is readily available, the second executor. Okay, reason number 1, a probated will names a specific devisee, but the executor attends the closing to execute the deed. This doesn't work because the executor does not have a power of sale over a specific devise. As we previously discussed, the executor has a power of sale over any property they own in an estate therein owned by an estate or trust, except where such property or any estate therein is specifically devised of. That means if you have a house, at 123 Fifth Avenue, the will reads, I give my house at 123 Fifth Avenue to Mary Brown. That's a specific devise. So we would need Mary Brown to sign as specific devisee. She would need to sign the deed. Now, if there's a case where an instance where the specific devisee is also the executor, that deed should not be an executor's deed. And it must be clear that the conveyance is made in the individual capacity. It would be wrong to be and ineffective to convey by using the executor's deed in that case, because they don't have a power of sale. A residuary devisee is not a specific devisee. So you got to pay special attention to the language in the deed to see, do I have a specific devise here, or is it just a general residuary devise? Do I need the executor, or do I need a specific devisee? Obviously, if it's not clear and you're at the stage where you're coming to a closing, give us a call and we'll go through it with you. Okay. Now there's some more scenarios there where does it include does the word, if you give the house, does it include a detached garage? This is all will construction matters. We're going to look at the intention of the testator. So, together with also, as well as, you're going to look at that. You're going to probably want the executor and the residuary devisee to execute, because we want to resolve that ambiguity. So obviously, not every will is drafted perfectly, and the language is not always great. Sometimes it's ambiguous. So we're going to want to take a good look at that. And again, reach out to us, reach out to the legal department here at Judicial, and we'll help you. We've got many years of experience, for title reasons or title purposes of reading wills and trusts and estates, and we can go through it and help you out. So would this closing be safe? No, unless the executor also happens to be the specific devisee. that executor has lost the power of sale and cannot sell the property. We would need the specific devisee to do so. Okay. Now, I added a slide to this about COVID-19 closing issues. Just really quickly what we're seeing. Is it really a closing if no one attends? It seems like no one really wants to come to closings anymore. The bank attorney is emailing the documents last minute to us, or overnighting them, to us to hold in escrow, or they're sending them to the closing. These can end up in adjourning because we don't know where the loan documents are if they don't get to us. Powers of attorney are being used. We're getting copies of documents rather than originals of deeds. We're seeing that quite frequently, and it's leading to some adjournments. The bank attorney will usually give us an escrow agreement. Sometimes the seller attorney will give us an escrow agreement. Here's the original loan documents and assignments from the bank attorney or from the assigning lender. Here's the deed and transfer docs. They're signed. Please hold them in escrow until I get my money. Be careful with this, because the title company, if you're the seller, may not accept an attorney's undertaking to get originals if there's copies involved, and we need originals to record, obviously. If you don't have a great relationship with the title company, you're a seller, you're representing seller, they may not take your undertaking. They may adjourn the closing. And also, who is, that's a typo, but who is dispersing funds? That's spelled wrong, but it's dispersing funds. I should have known that. But that is, is it coming directly from buyer to seller? Is the bank going to disperse funds, or are they going to wire everything to judicial title or the title company that you're using? And then judicial is put into the position of doing the lender's job and dispersing closing funds. Where that's the case, we're going to charge for that because it's a lot of extra work and a lot of extra liability. We're going to want to know how much we're getting wired and how many wires we're going to be sending out. We need clear wiring instructions. There's a lot of fraud out there with wires, so we're going to call everybody that's asking to receive a wire and confirm their wiring instructions. And we need invoices. We need to know who we're paying. Is it a broker? How much is their commission, and where is it going? So those are some of the things we're seeing now with a lot of remote closings. I apologize for having to speed through some of these, but I got behind on some of it. But I believe that is it, and I will open it up now to questions.
Yeah, so it's 2:00. You've listened to the lecture. If you need to log off, you can feel free to do that, but we're going to stay on for 5 more minutes just to answer any questions. I'm going to answer the first question. Somebody asked what taxes, if any, like the Peconic Bay and Suffolk, are there in Westchester? So we have like a cheat sheet.
Yeah.
You can't really see it. We do have it on our website also. So for example, in Westchester, Peekskill and Yonkers have a transfer tax. They also, in the last year, New Paltz added a transfer tax. But what we've done recently to your title report, at the end, there'll be this tax sheet, and it'll be specific to the deal you're working on. So it used to be this whole sheet where you had to look where it is, but now it'll be specific to the deal you're working with in your title report. So if you want to know, if you want one of these, let us know. We'll get them to you, but it's also on our website. So that's a question that we do get a lot, and we've worked on that recently. So now to the other questions. If a trustee is replaced by an alternate, must the real property be redeeded to the new trustee?
No, we would just need proof of the new trustee being appointed. We would need some kind of proof that they accepted the appointment.
Okay. Are you finding that banks are not giving certified checks anymore?
No, they give what are called bank checks. You can still get bank checks. Absolutely.
Okay. I've never heard of full consideration is required to be stated in the deed executed by power of attorney. Is this correct?
It is correct. Yeah, it is. It's not many people know it. Most people do realize it when you have an executor or an administrator or a trustee that the deed should, because they're fiduciaries. that the deed needs to state full consideration, and that is also the case for a power of attorney. I bet that is something that title companies miss themselves a lot because not many people know.
Can a religious corporation obtain Attorney General approval for sale instead of getting a court order?
Yes, if they get a Attorney General approval under the statute, that is good.
Okay. What are your thoughts on a payoff via wire directly to the lender rather than a bank check?
That's fine. We do that all the time. We just need proof that the wire went through. And obviously, you know, if we're sitting at the closing and we don't know that it's gone through and been received, you know, that may delay the closing, but it's not going to adjourn the closing.
Okay. I have two more quick questions.
Yeah.
If there are two executors appointed, but the will says that either executor may act separately, then will the title company permit the deed to be signed by either executor?
Yes, if the will is clear and states that only one needs to sign documents, then we're fine.
Okay. And last question, maybe, we'll see.
Never say that.
Warren, but in interest of ending on time, the last question that I had was, do you find final water bills or water bill readings hold up closings often?
They can, but you can always, if you can't get a final water meter reading, if it's going to take too long, the buyer and seller will hold an escrow back between themselves, and when the reading comes in, they'll pay out of that escrow and then refund the amount.
Okay, great.
To the seller.
Thank you, everyone, for coming. As a
Thank you.
reminder, I will send everyone all the material again and the affirmation this afternoon. So in case you missed it, you will have it. Everyone should get their certificates by next week. And thank you all for coming and supporting us. And we plan to do these through the summer. So, you know, you're on the beach with your phone, you can get your one credit.
Yeah.
So thanks again for supporting us, and we appreciate your business. Have a great day.
Thank you.